Does the defendant have anything to say before the court pronounces sentence?
I do, Your Honor. On her behalf, Ms. Davis is now... Ms. Davis has been incarcerated for 2 months since her conviction. She had been employed at Pure Foods. I show a lot of grit for this young lady to obtain a job of that consequence with less than a high school education, barely 19 years old. She's very remorseful about what happened to her children. As you can see from my sentencing memorandum, Children's Services spent a lot of time on this case, and they have concluded that her care of those children otherwise was good. She was permitted to live with her great-grandparents who now have charge with the children, and I'm pleased on Carlisa's behalf to know that Children's Services is going to terminate their protective supervision and allow the children to be in the custody of the great-grandparents. Carlisa would be allowed to live with them if she was given community control. I recognize we went through a trial on this case. She was convicted. Part of the reason for the trial was the state's very severe recommendation on this case. And also, I think the court learned through the course of this case that this was an act of recklessness, not purposeful, that she's 18 years old, that she has otherwise conducted herself in a good way, and that the children were otherwise in good health when this matter happened. Now, this certainly was a tragic accident. The jury has found her guilty of a reckless act, but I would still hope the court would consider community control on this case.
The victim or the victim's representative, Mr. Gruber?
I have something to say.
Well, I was going to ask that next, but first of all, victim's representative.
No, Your Honor.
All right, next you.
Yes, Your Honor. Concurrent with the state's sentencing memorandum in this case, the state is recommending the imposition of maximum consecutive sentencing for this defendant based upon the serious physical harm that resulted to the 9-month-old child and the 21-month-old child in this case. These children both ingested heroin on the defendant's watch. She exhibited a total disregard for their health and safety up until the time they ingested the heroin. And even after they ingested the heroin, when these children were at the hospital, this defendant refused to answer questions put to her by medical personnel about what could possibly be wrong with these children, which resulted in a delay in medical care. In fact, these kids were at the hospital for 30 minutes prior to the administration of Narcan, while medical personnel tried to ascertain what was going on with them. I don't know what else could be said about her callous disregard for their health and safety. I know defense counsel has characterized this as a reckless act on her part, but certainly her behavior after the fact was intentional.
Not convicted of an intentional act.
What's that?
She is not convicted of an intentional act. She's convicted of an act of recklessness.
I reviewed the evidence. The court will incorporate the pre-sentence investigation in this sentencing hearing, and I'm going to find that a prison sentence is consistent with the purposes and principles of sentencing, and that a non-prison sanction would demean the seriousness of the offenses in this case. Whether or not the court agrees entirely with defense counsel's argument about a lot of your socioeconomic situation and other items that they argued in their memorandum for the reckless conduct, I may not buy all into that, but I do take that into consideration. The problem is, and it was outlined by the state just now, that when you got to the hospital, you are extremely lucky that you're not facing 2 charges of involuntary manslaughter, to say the least. And if that were the case, you'd be going to jail for a long, long time. Your decision not to discuss what was happening to your children with the hospital, in the opinion of this court, is inexcusable, intolerable, and unacceptable. You will receive a determinate sentence of 30 months at the Ohio Reformatory for Women at Marysville on each count, which will run concurrently, and you'll pay cost. After your release from prison, you may have post-release control sanctions imposed upon you for 3 years. If you violate a post-release control sanction imposed upon you, you can get up to 15 months necessary to sentence. You have to sign.
Oh, I'm sorry.
You may be eligible to earn 1 or 5 days of credit for each completed month during which you protectively participate in an education program, vocational training, employment in prison industries, treatment for substance abuse, or any other constructive program developed by the Ohio Department of Corrections. However, these credits are not automatically awarded, but must be earned. Is it okay if the prosecutor prepares a sentencing entry?
Yes, Your Honor, while I serve a copy.
That's it.